you know, 200,000 emails between co-conspirators, your client is on 3 of them. And none of those 3 disclose anything really about the scheme. Hello, it's Lana Manitta from Ross & Law Firm again, and I'm here to talk to you today about criminal fraud in the federal system. Before we get started, be sure to like and comment on this video. Subscribe to our channel, where we provide educational videos on a wide range of criminal defense-related topics. Now, if you are a loyal fan, and why wouldn't you be, you'll know that I've told you that just about any crime could be charged federally because of the broad authority of Congress to regulate interstate commerce and even activities that have a minimal impact on interstate commerce. Now, we talked in another video about really why cases go federal, because almost any could. And so it has to be something that the federal government is really interested in pursuing. They're not going to pick up every single criminal case. The states handle the vast majority of criminal cases. So one type of criminal activity that is really often prosecuted federally as opposed to at the state court level is fraud. What is fraud? Generally speaking, it's criminal deception, lies or misrepresentations intended to result in financial or personal gain. Now, often the type of fraud is narrowed according to the context or the scenario in which the alleged deception or lie takes place. So, and some of them are fairly easy to figure out. So, for example, tax fraud is usually associated with actions or statements that are meant to deceive the IRS about someone's assets or expenses, and usually thereby reduce or avoid tax liability. Mortgage fraud is associated with deceptive activity in trying to obtain a mortgage. Then we have immigration fraud, insurance fraud. These are all examples of the type of fraud sort of being defined by the context in which it occurs. But there are some types of fraud that are not so easily understood or defined simply by the charge. One is honest services fraud. It's an interesting category, and it's commonly charged. But this involves a scheme to deprive another of the intangible right of honest services. Now, I know what you're thinking. Thanks. Now that I know the definition, that's not really particularly helpful. That doesn't tell me what this really involves. Well, honest services fraud usually involves a bribe. And it usually involves a person offering a bribe, a person accepting a bribe, and a person harmed by the bribe. The person harmed by the bribe takes on sort of the legal definition of person, which can be another kind of entity, not an individual human being, but it could be a corporate entity, it could be a nonprofit entity, it could be a government entity, or it can be a person. Now, usually the person accepting the bribe owes some sort of duty of honesty, we call it a fiduciary duty, to another. And by taking that bribe and for their own gain, they have breached that duty of loyalty, honesty, fair dealing, the fiduciary duty. They've breached that duty for their own personal financial gain. An example would be the coaches at various universities that took payments to recruit unqualified athletes to universities, right? Give preferential and even scholarship treatment to people who didn't know anything about the sport, and line their pockets with payments from their very wealthy parents. These coaches owed a fiduciary duty to the universities they worked for to find and recruit qualified athletes to the teams, right? And not defraud the university. And so that is one example of honest services fraud. It usually involves bribery. Other frauds that are even less defined are the vast categories of mail fraud and wire fraud. Now, these are really quintessential examples of the breadth of Congress's power, because these are really catch-all categories in which basically any fraud scheme can fall, provided that the mail or wire, which includes phones, computers, faxes, messaging apps, email, etc., provided mail or wire were used during the commission of the offense. What's worse is that because these fraud statutes, wire fraud, mail fraud, include this element, this separate element of using the mail or wire communications, they can be charged as additional counts. If there's a fraud statute covering the precise type of fraud, the wire or the mail fraud can be also charged as an additional count. They can be charged as conspiracies as well. And remember, I've covered this with you before. Co-conspirators are liable for the acts of their co-conspirators that are reasonably foreseeable. So, if it is reasonably foreseeable that your co-conspirator is going to get on the phone or use their data or their email or the internet as a part of the commission of the offense, you could be liable. Now, not surprisingly, white-collar defense attorneys see a lot of wire fraud counts. I can't think of a case on the white-collar side or the street crime side that doesn't involve the use of phones, computers, internet, messaging apps, or something, right? So, but just because something is easy to charge doesn't mean that it's easy for the government to prove. So while different circuit courts, and the circuit courts, in case you don't know, are the courts of appeals in the federal system. They're one step below the Supreme Court. And generally, because so few cases go to the Supreme Court, the law of a particular judicial district is covered by the law of that circuit. So the Southern District of Florida is part of the 11th Circuit. Most of the guidance that the Southern District of Florida gets in federal cases that the courts get is from the 11th Circuit Court. Eastern District of Virginia is in the 4th Circuit, and so on and so on and so on. So while different circuit courts have given different versions of the following sort of definition of fraud, this is generally what has to be proved to prove a fraud case. Number one, that a defendant voluntarily and intentionally either came up with a plan or participated in a plan, a scheme, to defraud another out of money. Number two, that the defendant, did this with the intent to defraud. Three, that it was reasonably foreseeable that interstate wire communications would be used. And four, that interstate wire communications were in fact used. And I want to be clear, this is for wire fraud that I'm talking about, not just fraud generally. Fraud generally is the deception to gain financial or personal gain, right? So this is the four basic elements of wire fraud. Now, as we've talked about, elements 3 and 4 are really difficult to overcome because it is at this point, 2024, pretty reasonably foreseeable that interstate communication is going to be used in almost every single circumstance, all day, every day, no matter what you're doing. And it's likely that if it was reasonably foreseeable that they would be used, they were. Remember, this is use of email, phone, messaging apps, you name it. The things that we're doing all day on our phones, if you're doing them and it's helping you even a little bit to commit the fraud, you're committing wire fraud. Now, so what do we do about that? Well, we focus on the first two elements, right? The client's mens rea, scienter, or state of mind. All of those really sort of mean the same thing. However you want to refer to it, that is most often where the theory of the defense lies for fraud cases. And that is knowledge and intent. Okay. It is not uncommon for a defendant to wind up, especially in a fraud conspiracy, without knowing that they have entered into a scheme to defraud or intending to enter into a scheme to defraud. Occasionally, in these types of cases, and they're common in federal court, multi-defendant fraud cases and conspiracy cases, occasionally the line between a victim of the fraud scheme and a willing participant in the fraud scheme can be very, very, very narrow, very hard to see. That's our job, to find it and draw it for the finder of fact, right? For the jury, for the judge, or in early negotiations for the prosecutor, without giving too much away. And, the government falls on one side of that line saying, your client was a willing participant, and we're on the other side of that line, but it is often a very, very fine line because, that's where the human element comes into play. Mistake, misunderstanding, misinformation. It's such a huge part of fraud allegations and defenses that these are winnable cases. And why is that? Well, part of the reason, and there's probably a host of reasons, but one of the reasons is it's often very difficult for even the most conscientious juror to see past, for instance, the gruesome facts of a violent offense, to really focus on and hone in on what was really going on in a defendant's mind, for instance, at the time that someone was victimized in a robbery or worse. Jurors just can't relate. But jurors can often relate to defendants who didn't know that what they were saying was untruthful, or they didn't say it in an attempt to take advantage or to defraud. So, motives, being misunderstood, saying something without full information, people can kind of get that because it happens to us in really innocuous ways all the time. But it's not enough to simply go to court with a fraud case and say, oh, ladies and gentlemen of the jury, my client didn't know. I mean, like it or not, the defense may not technically have to prove a case. There's no burden on the defense, but you've got to come pretty darn close. And at a minimum, you've got to have more than just a speculative challenge to the government's case. Fraud cases often involve hundreds of thousands, if not millions of documents in this day and age. And while the government will usually say, look at how large this pile is, not literally, but look how many documents we have, that proves your client had to know what was going on. It's often in just a handful of those documents that the defense is hiding. It could be the email where the client himself is lied to about the scheme, or where the client asks a question that indicates that he or she clearly was not part of the scheme or didn't have the right information to know that maybe a representation they were making was false. Or perhaps it's the fact that, well, there are, 200,000 emails between co-conspirators, your client is on 3 of them. And none of those 3 disclose anything really about the scheme. Now, what I've just given you are 3 real-life examples from fraud cases that I've handled. And so, as with any criminal case, it's important to have experienced counsel who are willing to put in the work, who take the time to get eyes on everything, who have a team of Hawkeye attorneys and legal assistants who leave no stone unturned and look for everything that's going to help and find that needle in the haystack to show a jury that the government has once again overstepped and overcharged and that a client should be acquitted. At Rawson Law Firm, our attorneys have that experience and that drive to do everything necessary to reach the best possible resolution for our clients. So remember to like and comment. Let us know what else you'd like to learn about. Subscribe to our channel, and thanks for watching.